Welcome everyone to our webinar on defending against human rights applications, something that is essential for any employer in Ontario and in Canada. So before we sort of begin, just a little bit about Achkar Law and what we do. We've been around since 2016. Our primary focus is on employment law, human rights law, which is a subset of employment law, labor law, and civil litigation. We serve all of Ontario. I'm Philip, my colleague is Charlie. We're very happy to be your hosts today, and we hope that you find this presentation informative and interesting at the same time. So the first question, what is a human rights application? So as an employer, you may be in a position where you have other employees, and you may at some point or another receive a complaint for an employee or be informed that there's a human rights application filed against your company. A human rights application can take many forms, but typically what a human rights application is it's a complaint by an employee that they have either been discriminated against by the company or that the company has failed to accommodate them, or both. When you receive a human rights application, the most important thing you can do is obtain counsel, because unfortunately, anytime you do receive an application, you must respond. And in every response that you receive, there will always be a deadline window for responding. So when you do receive a human rights application, the most important thing you can do is actually respond, and more importantly, respond by whatever tribunal, whatever deadline you receive from the Human Rights Tribunal of Ontario or the Canadian Human Rights Commission, as the case may be. Essentially, if you are a provincially regulated employer, you will receive an application at the Human Rights Tribunal of Ontario. If you're a federally regulated employer, you will receive an application at the Canadian Human Rights Commission. Both the Human Rights Tribunal and the Commission share sort of a similar function, and both pieces of human rights law, so the Human Rights Code for provincial employers and the Canadian Human Rights Act for federal employers, have the same gist and spirit and cover the same issues and themes. Now, there are some minute differences in terms of processes, procedures, and so forth, but ultimately both statutes deal with either discrimination in some form or a failure to accommodate, or both. And although this is not the subject of today, it's worth noting that discrimination doesn't just happen in the employment context. It can happen in the area of social services, for example. What should be in the response? Imagine this. You've received a human rights application. In that application, there are a bunch of allegations that you or someone in your company either discriminated against an employee or failed to accommodate them for some medical issue. The most important thing you can do is first gather all your evidence. So any medical documents you have, if it's an accommodation case, any information you have from, for example, a manager that was involved, any other evidence. Typically, you'll know what might be relevant because a lot of the issues will be brought up in the application. And the most important thing you can do at the beginning is basically a hunt, fact find, gather of information. You want to know not only what the case is against you, but what your side of events is, right? There are always two sides to every story, and this is certainly the case in human rights claims. So the most important thing you can do at the beginning, gather evidence, find out who was involved, what they were involved in, and essentially prepare a response that sort of covers and highlights all of the things that happened from your perspective in chronological order. And I can't stress this, when you retain legal counsel as well, this is relevant because I can tell you for a fact that when we have all the information organized and chronicled properly, it's a lot easier to prepare a proper response and challenge each and every allegation that's being alleged. Because the point of a response is you want to cast doubt on every single allegation that is being made by the employee without question. Bear in mind also, sometimes you may receive an allegation that's entirely frivolous, and that may be your response, that it's frivolous. So don't be surprised if you ever do receive an application and it either doesn't make sense, isn't accurate, contains something overblown, exaggerated. The tribunal, although they have a screening process for these types of things, generally it takes some time to get there, and nothing stops an employee from filing whatever they will. So always you want to answer everything that is being alleged, point by point. Typically, what happens in terms of processes is you'll receive an application. You will have some deadline to respond. The deadline is always different, but usually you get about a month from when you've received an application to file a formal response. And once you do respond, at some point or another, the tribunal will reach out to the parties to schedule what's called a mediation, which is essentially an attempt by the parties to meet and try and resolve all of the issues. Some of you here today may be familiar with mediation. You may have mediated before on behalf of your company, whether for a work matter, maybe even some private matter. But mediation is typically the first step in any human rights case before a hearing. So essentially, there are always two steps. The arguments are exchanged. The matter gets scheduled for mediation, assuming that all parties agree. It is optional and usually worthwhile, mind you, even though it's optional. So, and most people agree to mediate. And if mediation is not successful in the rare case, then the matter eventually gets scheduled for a full merits hearing. And that's kind of like what you may picture when you watch those legal dramas where, the parties are in trial, they're asking questions, and one side is trying to prove the case and the other side is trying to disprove the case. Why is it important to spend time defending a human rights application? Simply because just like an employee is making a story in their application, your response is your opportunity to tell your story, because you may have a completely logical and rational response to what is being alleged. Or maybe what's being alleged is absolutely false, and you can show that. Doing all of the groundwork at the beginning is very important because a proper response can save you not only from that lawsuit that's been commenced, but just from everything in general. You always want to invest the right amount of time in the beginning in getting a proper response. I can't stress that enough. It's extremely crucial. You get one good shot, proper response. So it's very critical. The tribunal has other sort of processes. They're called commonly requests for order. And requests for order are basically procedural steps that you can use while in a case to ask the tribunal to do something for you. So to give an example, if an employee files an application and claims that on one sunny day, he was called stupid. That's his claim. So now, being called stupid is not necessarily a human rights issue. It's maybe a bullying and harassment issue, but it doesn't have anything to do with human rights. And just to sort of draw a comparison, if someone says you are stupid, that is a example of bullying. If someone says you are stupid and mentally ill, that is an example of discrimination, because now you've brought in that element of disability, and that's what makes it more than just mere bullying. So to go back to my previous example, if an employee alleges that he was called stupid 20 times, and there's no connection in that allegation to the employee's race or gender or religion or the language they speak or their ethnicity or a disability they have, if there's no connection to any of that, the claim is probably frivolous, and you can use the tribunal's request for order to have the claim thrown. So that's what's called asking for a summary hearing, which is basically a fancier way of saying having a quick trial to get the case thrown because it doesn't have any relevance or merits to go on to the next step. So think of it as like an expedited process that the tribunal has. So essentially, it doesn't always just end once you file the response. Although mediation is like a first step, there can be many other steps. And this is the same for both the Human Rights Tribunal of Ontario and the Canadian Human Rights Commission. Although they sort of follow the same beginning procedures in that an application is filed and a response is filed, at any point in the litigation, there can be other steps that happen. And it's always important to be sort of on the lookout for that and prepared to respond. And there are many things that a party can ask for. For example, as an employee, if you are at the workplace and someone discriminates against you and you file an application, and then after you filed, there are new instances of discrimination, you as the employee can ask the tribunal to add those new events to your original application. So it's always important to be sort of on the lookout for these types of things and to be prepared to respond to any issues that may come up. It's litigation can often just be unpredictable, and the best way to prepare is to, again, most importantly, have that response prepared at the beginning, gather your information, make sure it's organized, have it all provided in a way that sort of tells the story that you want to tell. And the goal is ultimately to show that there's no human rights violation, to have the application thrown. And again, it's unfortunate, but for both the tribunal and commission, there is no consequence of filing and filing wrong. So employees are not necessarily discouraged or dissuaded from, commencing any type of application they want. And regrettably, even if an application is commenced that is either, frivolous, makes no sense, completely exaggerated, overblown, and so forth, you still have to defend. The simple reason is because if you don't defend at all, if you just put it off and ignore it, the tribunal or commission may ultimately decide that your silence is the same way of saying you are responsible for what happened. So I can't stress it enough that no matter the type of application you get, no matter how frivolous, no matter how, nonsense it may be, it's very important to respond and to follow whatever deadlines you receive. And the deadlines you do receive will always be outlined in a letter. And so you'll know what's next and you'll know what's ahead. So that's why the best thing you can do, if you ever do receive such a application, you want to inform a lawyer immediately and start gathering information immediately. Because although 1 month is a decent amount of time to respond, time also goes quickly, as we all know. And, within the snap of a finger, the responses do. So always be diligent and keep the deadline in mind. Very crucial for your company and very crucial just for getting ahead of any complaints that you've received. You may be fortunate enough that you've never gotten any such complaints, and that may be the case. Even then, don't treat it as anything sort of not serious. It's very serious, even if it doesn't appear to be serious at the time you receive it. So treat every application you get the same way.
In terms of avoiding a human rights application, the simple answer is you actually can't avoid an application coming your way, but what you can do is prepare for one. As Phil said, the Human Rights Tribunal and the Commission doesn't have really a good screening process for even stopping completely frivolous claims that were without merit. And because there's no cost consequences, there's really no deterrence for employees to bring things forward. So in regards to dealing with the human rights application, the best offense is a very good defense. And in fact, your best defense and response starts well before a human rights application comes across your desk. So limiting your liability when an application might come around can start with first establishing some workplace policies in terms of saying, hey, we have a workplace policy for being against discrimination. We have a workplace policy for how to handle accommodation requests. And we have a workplace policy for how to handle if someone wants to come forward and complain about discrimination in the workplace. It's good in those policies to also have a designated person that they can go to and to have a whole step-by-step template for what you as the employer can do when these things occur. Because investigating reports of human rights violations is your obligation under the code and the commission. If an employee approaches you and says, hey, so-and-so has discriminated against me, you have an active duty to now investigate that. So having a template in place for how to investigate it is going to go a long way for you. And in particular, it can actually curb and potentially stop any potential application if you reach a resolution that all parties are satisfied with. Many people don't necessarily want to go through the stress of actually drafting an application and fighting for human rights. They just want the matter to be resolved. And if you already have the solution in hand, bully for you. Excellent. And also, with regards to building off of what Phil said about your response, having these policies and your investigation, including all the notes you took on your investigation, will be excellent sources of evidence in your response to show your side of the story. Workplace discrimination isn't always clear-cut. Sometimes it's meritless, and sometimes it's completely clear-cut. But telling your side of the story is extremely important. Now, discrimination doesn't always mean someone said something against my basic human rights, such as, against my race, my religion, color. Sometimes discrimination occurs in a failure to accommodate. As an employer, you have an active duty to provide accommodation to anybody who asks for it, but there's a threshold. You're not expected to accommodate every request under the sun. The threshold is you must accommodate up to undue hardship. And what that means is that if it's a reasonable accommodation request that you can do, you must do it. But if it's something that is well beyond the scope of your capability to fulfill, then you're not expected to. But that threshold is quite high, and it's not enough to simply say it would be too expensive or be too onerous or difficult to pull off. Specifically, there are a few key aspects a tribunal or commission will look at when deciding if you've met your duty to accommodate, such as what was the actual cost of this accommodation? If you've got an employee who needs ramps around your building, and let's say it's one or two, and you could possibly afford it with your revenue, you should be able to. But if it's an exorbitant price to make this accommodation, chances are the tribunal or commission will be much more forgiving. Though you must also do your best to look into any sorts of government or provincial, federal financial support systems that can go into place to assist you in providing those accommodations if you're going to allege costs. Another big issue is health and safety concern. Sometimes an accommodation request is just untenable because it would be unsafe to do so. For instance, let's say you have an employee who drives a forklift in your warehouse, and due to some injury, he loses both his arms, can no longer operate the forklift, but then the employee approaches you and says, "Don't worry, boss, I can operate the forklift with my feet. Please accommodate my request." Well, I don't know how dexterous someone can be with their feet in operating a forklift, but quite possible this would not be a very safe approach to accommodating this request. You might need to find some other options for the fellow. That's one example, and many other also exist. Now, your duty as well, again, you've got the policies, you've got your investigations, you've got your active ready to accommodation. It doesn't just exist for active employees. In fact, in Form 1 of a human rights application, they tell you when in the employment relationship did you experience discrimination, hiring, during it, even at termination. So when you're hiring somebody, you have to be mindful of ensuring that there's no discriminatory conduct, and also accommodations are in place, and that you're prepared to accommodate incoming employees as well. Having all those policies and blueprints in place, especially helpful if it's drafted by an employment lawyer, will guide you in such a way that any application coming against you would just be completely without merit. Termination is also another very risky time. We can do webinar after webinar about your duties at termination, but it's safe to say right now that, as you know, terminating employees is a very sensitive time. And sure enough, your duty to be mindful of discrimination or accommodation requests is very much heightened if you're letting employees go. Always speak to a lawyer first.
I'll add one quick point, and this is something a lot of employers maybe don't think about, but it's definitely something to be careful around. So if you ever do have an employee who's complained about human rights and you decide that that person's complaint is disrupting your workforce, causing problems, you don't like receiving a complaint, one of the worst things you can do is actually punish that employee. And that's what's called a reprisal and reprising against the employee who's complained. So, typical example, an employee complains about discrimination. The employer turns around and fires him because the employee complained, because, the employee has brought some negative attention to the company. This is sort of textbook reprisal, and it can actually expose the company to greater damages. So you always want to be very careful with how you respond to someone who has lodged a complaint, because keep in mind, employees who complain can either be past employees, meaning you've fired them and they're claiming there was discrimination, or they've claimed discrimination and they continue to work for you, in which case you have to be extra, making sure that you're not treating them differently or punishing them in any way just because they've lodged a complaint. Because the Human Rights Code and the Canadian Human Rights Act do give employees the freedom to file complaints, and that freedom should not be disturbed. So certainly if you ever have an employee that's working for you and you've received a complaint from that employee, first thing you want to do is tell a lawyer, because you got to manage that, get ahead of it, and make sure you don't do anything rash, because that's the worst thing you can do.
How would this apply to accommodation for addiction and alcoholism? Fantastic question. So, in terms of alcohol and addiction, this is a very tricky one. And one of the things to be mindful of is, are there any health or safety risks in terms of working with somebody who has addiction to alcoholism or drugs? Well, the fact remains that if they are in a safety sensitive position where they could be an undue danger and they've already exhibited signs of being, let's say, drunk or high on the job, then you might consider there might be some undue hardship present. But this is very tricky. Very careful. Keeping your ducks in a row and gathering all the evidence is something to do. And also, you may be required to take steps to assist them with seeking help, such as addiction counseling, or perhaps go into any sort of program rehabilitation.
In terms of accommodation, it is, yes, because on the one hand, you have an employee who has an issue with alcoholism. On the other hand, the role that this employee occupies may be safety sensitive, and accommodating that person may actually be tricky. Case in point, I would imagine it would be difficult to accommodate, for example, a laborer who operates, heavy and dangerous machinery, or maybe is in charge of other people, and it's, sort of a potentially hazardous work environment. I mean, accommodating alcoholism in that kind of a scenario could be more tricky and less straightforward than, for example, accommodating an alcoholic who works as a customer service representative. So, and it's this intersection between balancing your health and safety obligations as an employer generally to not just the employee you're accommodating, but everyone, and also that employee's rights to accommodation. So it is tricky, and certainly it is taken on a case-by-case basis. But again, if we recall what Charlie had mentioned earlier, the standard is undue hardship. And what that really means in, the simplest of terms is you have to do your best and you have to explore and exhaust all of your options before you say no. That's the duty. Sometimes, speaking openly, sometimes it may be impossible to accommodate someone. It may literally be impossible. But as long as you've done that, you've looked into it, you've done the groundwork, you've investigated, you've researched, you've explored your options, the outcome may be that it's just not possible. But still, the duty is to look into it. So
exactly. So we have another question. When an casually or randomly says or claims they have mental health issues, would it be best to approach from the employer to immediately address this and request for medical documentation, as we know employees use mental health as a scapegoat? So with regards to that particular situation, it's best to take every sort of allegation as a legitimate one, but also do your due diligence. Every time someone comes to you with an accommodation request, it's not up to you to determine if it's legitimate. In fact, that's a burden you can take off your chest. They have the responsibility now to you hand them over what's called a functional abilities form, or FAF, and have them take that to their doctor to confirm what those accommodations are that they required. As an employer, you don't necessarily need to know, is this legitimate? What's the prognosis? What's the diagnosis? You just need to know, how do I accommodate? And you leave it to the doctors or psychiatrists to determine if this is a legitimate claim. If they refuse to come to you with a functional abilities form, well, an argument could be made, how could you possibly accommodate no accommodation request? Follow-up question you may have is, what if I doubt their doctor? You are well within your right to ask for an independent medical examination, an IME, if you think for whatever reason that this is just some illegitimate doctor's report, or to ask for any sort of clarification. The straight result is, treat it seriously, but with doing your own due diligence to make sure, how do I accommodate you? And let the doctors decide if this is legitimate or not. In fact, deciding on your own if it's legitimate is a one-way ticket to a discrimination.
Yeah, so don't ever dismiss any employee. For example, you may have an employee who is, let's say, a troublemaker, has that reputation. And that employee may come to you with a request for accommodation, and you may think to yourself, well, this employee has caused trouble before. They're probably making things up. They just want some time off. Don't assume, because it's dangerous to assume. And again, let the medical's functional abilities forms, let that speak for what's going on. Don't assume on your own, and treat every request seriously. That's the best way to get ahead of it. If it's not serious, you'll find out eventually, right? But at least do that digging before you draw any conclusions, because drawing early conclusions prematurely can be very, very dangerous.
For frivolous claims, is it better to pay the applicant some money and settle early or defend? And how fair and credible are internal investigations as they are paid for by the employer? Um, to touch base on that, so our Achkar Law, we do actually workplace investigations as well. We're often hired as a third-party investigator, and our investigations are completely independent. And as an employer, you want to do the investigations yourself. And when it comes down to questions of how credible something is, that's for a trier of fact to decide. Just because it is the employer or an employee of the employer doing the investigation doesn't mean it's not credible. Leave it to a trier of fact to determine if your investigator is credible. But having that investigation and the fact that you have a policy in place for these investigations goes a long way to establishing you're a credible employer who can be relied upon to go forward with trusting what you've written down. And as for frivolous claims, is it better to pay the applicant some money or set it early or defend? I'm going to give you the favorite lawyer answer of it depends. As Phil said, you don't get cost awards, even if it's a completely frivolous claim. You can go all the way to a tribunal, be completely right. The tribunal member can say that the application was absolutely meritless, and you still won't get your costs back. So deciding if it's better to put some money or nuisance settlement forward, if you will, is a question for you and your legal counsel to discuss strategically.
Someone asked, what is the maximum they can be rewarded for human rights? So this is specifically in the employment context. But basically, you have sort of two heads of damage. You have what's called general damages for alleged injury to that employee's dignity. And you have a potential for lost wages if the employee has lost a job because of the discrimination and or failure to accommodate. Damages for injury to dignity can be anywhere from $0 if if the claim is completely frivolous to it really depends on the type of case. So for example, if you have a particularly egregious sexual harassment case, the damages can be well over $100,000. And that's been the case consistently. If you have a case that is actually, I can give an example. There's one example that always comes to mind. There was a case that happened a long time ago. I believe it was in 2005, if I recall. And the manager of one company discriminated against a Black employee by referring to the employee's choice of attire as a ghettoville. So he said that the employee dressed like ghettoville. Obviously, it's stereotyping, it's discriminatory. And in that particular case, the employee didn't receive much in the way of damages because the incident happened once and the manager was trying to just, make a very vulgar joke. Nonetheless, it was discriminatory. Anyway, the damages there were $2,500. But if you've been hit with a sexual harassment claim and you have an employee who claims that they were discriminated against on the basis of sex, gender, and so forth, the damages can be much greater. There's one case that we often refer to in our circles. The case involved a tattoo parlor, and the owner of the tattoo parlor had a minor. I think she was 16 at the time, a young girl that he hired to help him design tattoos. And he sexually harassed her and did some other very vulgar things. And the fact that she was a minor, in addition to the sexual harassment, led to a very high damages award. It was well over $200,000. It was one of the landmark cases at the Human Rights Tribunal of Ontario. So basically, the answer to the question is that there's a range. The average range is about maybe $15,000, depending on the facts, but the damages can be greater if the employee lost their job because of discrimination and they've been unemployed for a long time, or they can be smaller if the incidents didn't happen often, there was no job loss, and sort of some of those issues have been dealt with it. But again, every case is different. So it's a wide range. And that's why we really, really emphasize that it's always important to get ahead of any complaint because it is such a wide range that you want to make sure you cover all your bases and you don't fall into any traps because some of the damages awards out there have been pretty big. So case by case basis. Contact us if you have any other questions. I know we've given everyone a lot to sort of digest in this short little time. We hope this was helpful. And certainly if you have any other questions, let us know. and we'll be back here in this same space next week. So again, we thank everyone for taking some time to be with us today and to hear about defending against human rights applications. And let us know if you have any questions, and we'll see you next week. Thank you all.
Have a wonderful afternoon, everyone.